2025. Is that true or not true?
It's true.
Count 2 alleges that you committed the offense of criminal trespass on August 10th of 2025. And is that true or not true? Count 3 alleges that you failed to remain off the premises of any bar, tavern, or lounge, and that you were at Little Woodrow's August 10th of 2025. Is that true or not true?
Sure.
Count 4 alleges that you were at a location other than your residence at approximately 1:37 a.m. You are Jermika August?
Yes.
And this is 21-36752. And Ms. August is currently on probation for, looks like the state jail felony offense of unauthorized use of a vehicle. And there's a motion to revoke that probation.
Yes, sure.
And so where are y'all on?
We have not entered pleas on this case, Judge. We have discussed if the court would consider entertaining a 1244 due to the fact that she has recently found out that she was pregnant. I think her involvement in this offense would suggest that 1244 might be something to consider, but in all honesty, I didn't send the paperwork because if she's pregnant, if she's having all these issues with the positive test that Ms. Kane can discuss, it just, I want to help her. I want to help the baby more than I want to help her, but I know they won't take her in any of our programs because of that. She's been extended on probation, so
Yes, ma'am.
she's towards the end, and it's my understanding from Ms. Holmes, who's worked very hard on it, that she just wants to sit out her time, but you understand my concern with the situation that she's in. It may not be the right thing to do, just to let her go sit there for a little bit of time, and then we have no idea what she's doing and she's pregnant.
And in regards to, I know there was a recent drug patch result. So Ms. August, to my understanding, has denied any substance. The drug patch keeps registering saying cocaine, which was, as I think the results were from last week. And so that's why we asked if she could drug test today, because she has denied being, using those substances. But we do understand the concern, but we wanted to, I guess, shed some light or give, I guess, everyone, let them to breathe a little easier, with her taking a test today showing she didn't have anything in her system.
And she tested in court also, it looks like March 2nd, and tested negative.
Right.
And then there was a drug patch that tested negative back in. So there's been kind of both. How far along are you? That was.
You know how far along your pregnancy?
I just found out literally like four days ago. My first trimester. So.
I mean, it's the type of case and the type of issues on a case that a 1244 has been fairly normal. I understand and have the same concerns, but I don't know that forcing anything is the thing to do, or if it's the fair thing to do either.
I just wanted
Yeah.
these issues to be.
I'm with you on
aware.
what I'm concerned about, Miss August. I mean, we're both concerned, and I know everyone here, your probation officer, even your attorney, we're concerned about your baby. My concern for you kind of goes away once I know that you are with child and have had some issues with drugs. We want your baby to be safe, but you've also been on probation for a state jail felony for longer than you would have been doing state jail time with some hiccups. So it makes sense what they're talking about, but if you're having issues, you need to do whatever you need to do to be safe and have your baby be safe. Okay?
I'll send that paperwork.
Thank you. All right, I'll take care of it. Y'all have a seat and I'll take care of it as soon as it comes through.
Okay.
And is the intention for Ms. August to go today and be
Yes,
sentenced? Okay. And all right, ma'am, again, you are Jamaica August.
Yes.
And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. August, in cause number 21-36752, I have a motion to revoke your unadjudicated probation. shows that you were placed on probation November 28th of 2022 for the state jail felony offense of unauthorized use of a vehicle. And that was a 2-year deferred probation, and that's been extended. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the new offense of resisting arrest, search, or transport on August 10th of 2025. Is that true or not true?
That's true.
Count 2 alleges that you committed the offense of criminal trespass on August 10th of 2025. And is that true or not true? Count 3 alleges that you failed to remain off the premises of any bar, tavern, or lounge, and that you were at Little Woodrow's August 10th of 2025. Is that true or not true?
Sure.
Count 4 alleges that you were at a location other than your residence at approximately 1:37 a.m. on August 10th of 2025. Is that true or not true? Count 5 alleges that you failed to abstain.
And here's where things start going off the rails. The defendant is using a mix of sovereign citizen-style arguments, talking about trusts, jurisdiction, and fictitious entities. But in real courts, these arguments almost never work. The judge isn't confused. She's just waiting for the right moment to shut this down. I carry a message for the elder. Step aside, or I will force my way through. This is where the case starts shifting from a standard probation violation into something much more sensitive. When pregnancy enters the courtroom, judges often weigh punishment against protection, especially for the unborn child. What do you mean? We don't have time for games. It's too late. The shadow. It reached him first. You need to leave. Now!
Abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample July 29th of 2025 that tested positive for marijuana. Is that true or not true? And then count 6 alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have here on the tablet some documents that, oh, it's county jail, not state jail. Correct.
Plus 44, yes.
Okay. There's a spot for county jail.
Oh, yes.
With y'all's permission, I'll
Yes,
make
ma'am.
that change. Okay, I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Ms. August is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. And at this time, I find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 8 months in the Jefferson County Jail under section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. I really do. We all hope that you make the changes that you need to, so you can raise your babies and nobody else. All right, you can go back to the bailiff. All right, again, sir, you're Correll Gilbert.
Yes, ma'am.
And Mr. Gilbert tested negative for everything. And so Mr. Gilbert was previously in court in cause number 25 DCCR 1009. Entered a plea of guilty to the 3rd-degree felony offense of driving while intoxicated, 3rd or more. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Yes, sir.
Any additions or corrections?
No additions or corrections, Your Honor. However, we did have one recommendation item we're calling.
Sure.
Nothing finished up.
So with regard to, obviously, the recommendation here is for, safety. What is your request on that, Mr. Chavarria?
May I make argument with that or
Yeah,
just?
go ahead.
Okay. Our specific request is that that be held in abeyance and that Mr. Gilbert be asked to submit to some recurring UAs so the court is satisfied with his compliance and his progress on this offense. I will note a few things, Your Honor. Mr. Gilbert took responsibility for this as part of the pre-sentence investigation. He took responsibility for it at the scene, actually, as well. He has been working at a good job with good pay for about 3.5 years, Your Honor, as a welder. And he's married. He has mortgage and car and all the normal things that people are expected to have. I think he's in a good position in his life, and submitting him to this safe would be a major disruption to that. As for the actual plea agreement that was agreed upon, safety was not requested by the state. That was not part of the specific terms at that time. He was also seen by a individual named Miss Melissa Posey, who's a licensed chemical dependency counselor, and that's on page 3. And her recommendation was that he enroll in and successfully complete an intensive outpatient program, such as a JCDI. And we would be in agreement with that as well, Your Honor, if that's appropriate, in lieu of the safety.
What's your position, Mr. Smith? Are you?
Judge, it wasn't part of the plea agreement. I didn't think that it was necessary at the time that the plea offer was made. The only thing that concerns me is the fact that he tested positive for alcohol when he did the concern, but we would leave it up to the court.
Was there an alcohol test done today on Mr. Farrell? It doesn't show that. Do you have the alcohol test that you can do today?
Yes, ma'am.
I meant for that to be done as well. Can y'all get that done real quick? Let's test for that.
Thank you.
Sure, sorry, I'll hold it again just for a minute. Have a
11.5 years.
Okay, so you're Thomas Valentine. Did y'all have an opportunity to visit Mr. Rojas
We did.
about the paperwork and I guess the
Yes, ma'am, it was a miscommunication, but both of us, I actually wrote 16 months. He remembered signing 16 months, but we obviously made a mistake. Paperwork says 18. If the court remember, he has credit for enough credit to cover the 18 months either way.
Okay,
And so we just want to make sure that that we were both okay with the 18 months.
okay. Any other issues? All right, then, Mr. Valentino, I'm going to find that you previously entered your plea of guilty freely and voluntarily. At this time, find sufficient evidence to find you.
And here's where things start going off the rails. The defendant is using a mix of sovereign citizen-style arguments, talking about trusts, jurisdiction, and fictitious entities. But in real courts, these arguments almost never work. The judge isn't confused. She's just waiting for the right moment to shut this down.
I carry a message for the elder. Step aside or I will force my way through.
Now the tension spikes. Drug patch results versus denial. This is exactly where probation cases turn critical. One side of the data says violation, the other says not proven, and the judge has to decide who to believe.
What do you mean? We don't have time for games.
It's too late. The shadow. It reached him first. You need to leave. Now.
Guilty, and in clause number 25, DCCR 0121 finds you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You do receive credit for any time that you were in custody, that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back to the bailiff.
And Judge, if I could just for Mr. Valentino's benefit, the last time we were here, we checked his credit. He has 655 days credit. It wasn't attached to this case because he didn't have a hold on him, but the court had agreed to give him credit for that last time we were here.
What was it on? What was he sitting on? I remember talking about that.
It
was straight from us. And never left custody.
Yes.
Right.
Yeah, so.
So I gave him credit from the day that he was arrested on our case because you never got out. Correct.
Mm.
Okay, you'll get all that credit. We'll take care of
May I
it.
ask you also, Your Honor, would you be able to, would the court be able to
He's asking if there's anything the court can do to make sure, he knows he's gonna have to sit for some period of time until state jail gives him the okay to be released. He's wondering if there's anything the court can do to speed up that process.
My clerk is very efficient, so we'll have your judgment done within a day or two max. And so the jail will have it this afternoon or tomorrow. And then it's up to state jail to get back to them and get you, I guess, your number and hopefully get you out from there. But that'll be all up to them.
But you got all the credit, right?
You have all the credit. Yes, sir.
It was 655.
Yes, sir. From the date of the arrest, because you never got out, we're giving you credit for all of that.
Thank you.
Yes, sir. Take care.